The D.C. Court of Appeals issued a major ruling saying that Donald Trump was not shielded from liability because he was president at the time he gave the speech on January 6th. This is in a lawsuit involving Capitol police officers who are suing Donald Trump, among others, for their injuries. But this case has implications, of course, not just for the civil case, but for his criminal case in DC, because Donald Trump is trying to argue essentially the same thing, that he should be shielded from criminal liability based on the fact that he was president at the time of his speech. Now, one of the most interesting and perhaps telling things about this case is that a Trump appointee, Judge Katsas, did not dissent, but issued a concurring opinion. My name is Dina Sayegh with the MeidasTouch Network. Let's break this down. So the reason why this is so important is because this was a unanimous decision, and the fact that Judge Katsas, he was appointed in 2017 by Donald Trump. He clerked for Justice Thomas while at the Supreme Court, and he was a lawyer in the White House. He was essentially Donald Trump's White House lawyer before he was appointed by Donald Trump to the Court of Appeals. So this is somebody who you would think, if he was going to, continue his ideological opinions in favor of Donald Trump, which he has in the past, and I'll talk about that a little bit, he would have dissented here, because this is, of course, a huge opinion against Donald Trump. This fact that he's going to have to face this lawsuit. I mean, Donald Trump can again bring up this argument. This was only in a motion to dismiss, which meant that he can the Capitol police officers can continue their lawsuit against Donald Trump. Basically, the judges said, if all the facts are as the plaintiffs say, then he is liable, that his actions are within his personal conduct, not his official conduct. And so he's not shielded from immunity. But these arguments are going to be coming up again by Donald Trump. He's going to argue this in a motion for summary judgment. So this is not going to be the last we hear Donald Trump make this argument, even in this civil case. We know he's going to be making it in the criminal case as well, because once you go farther along, the facts of the case are going to be discussed more, let's say, by the parties and evaluated more by the judge. And whether or not he even overcomes a motion for summary judgment, we may also see this, in trial. But to get back to the fact of why it matters so much that this Trump appointee was unwilling to do a dissenting opinion in this, but a concurring opinion, shows how strong the law is for the fact that Donald Trump took these actions in January 6th in his personal capacity and not his official capacity. So let's talk a little bit more about Judge Katsas. I was saying how he was the White House lawyer, was appointed by Donald Trump. He took a decision. You may remember this because this was a rather big decision at the time when having to do with contraceptives. And Trump had decided to not give them access, specifically changing the criteria for awarding contraceptive and family planning community grants without the congressional required public notice and comment. And it was this judge that voted allowing the Trump administration to not have judicial review on this. So clearly he's acted in the past very aligned with the Trump administration, very aligned with the Trump policies. And so his decision here for not kind of standing as the protector to Donald Trump is huge. It's massive. And let's go into his opinion exactly and see how he has to say it. And again, if this was from another judge, we may not have been as surprised about this, but coming from him, it is hugely significant. So he in his opinion, he says that it says, the courts may reliably conclude that a sitting president is speaking only in a private capacity as a candidate for re-election or as the leader of a political party. These include instances where the president speaks at a party convention, in a presidential debate, in a political advertisement, at a campaign rally, or at a party fundraiser. Second, the operative complaints plausibly allege that the January 6th speech involved this kind of purely private campaign speech. Again, he says it plausibly alleges, basically saying it's reasonable. It's a reasonable allegation. He is conceding here that the complaint is giving a reasonable allegation that the January 6th speech that Donald Trump gave involved purely private campaign speech. And this is coming from a former lawyer, White House lawyer for Donald Trump. Okay. Then he goes on to say, in particular, the complaints allege that the January 6th rally was organized by campaign staff and funded by private donors and was neither facilitated by White House staff nor paid for with congressionally appropriated funds. Those are huge facts. Will Donald Trump be able to put forward any facts later in this trial that disputes that? I think it's highly unlikely because those facts are facts. Again, it was organized by campaign staff, funded by private donors, and not facilitated by the White House staff or paid for by congressional funds. It was private actions that even this Trump-aligned judge cannot argue away, cannot do anything but concede that this is the fact. And he's putting this in his opinion that now can be quoted and used by Judge Chutkan in her DC court. Like, you realize that she is in that same, she is also in DC. This is the appellate court that is going to review her decision that she's going to make of whether or not the conduct by Donald Trump on January 6th and leading up to January 6th can be criminally prosecuted. We know he's arguing that this was his official capacity and not a personal capacity. She's going to be writing her own opinion on that. It will be appealed. We know it will be appealed. It is going to be appealed to this same appellate court. Different judges may be assigned to it. But when we see one of the most closely aligned Trump judges take a position such as this in his appellate review, I think it's very reasonable to assume that the judges will take a very similar ruling and allow Jack Smith's criminal prosecution to go forward in Donald Trump and will not shield him from liability, saying that it's an official act. For one, they're going to be able to quote all these opinions, and they can even quote Judge Katz's opinion, this Trump-aligned judge. So it is a box that's getting smaller and smaller for Donald Trump. So let me just read a little bit more from his opinion here. Okay, so it's given those allegations. Again, these are still allegations. If Donald Trump will have to disprove these facts in order for him to overcome this opinion, in order for him to be shielded, he will have to overcome these facts, which I don't see how he's going to be able to. And he hasn't tried to overcome the facts. So I'll tell you a little bit more about what his lawyer has tried to say, but it hasn't been trying to overcome these facts. So given those allegations, which remain to be tested on summary judgment or a trial, which is what he's saying, is that, Trump is still going to have a chance to talk about his facts. He hasn't yet. So it doesn't seem like there's different facts, but he's going to have a chance. It says, we cannot resolve the immunity question in President Trump's favor at this stage of the case. Again, a huge kind of nail in the coffin for Donald Trump's ability to use his office of the president as a shield from immunity in both the civil case and in the criminal case that's coming up. What is the Trump attorney is saying, Jesse Benall said at the oral argument in relation to this case, was you cannot separate the governance from re-election. If the president wants re-election, it's so he can continue to govern. So they're not saying, disputing these allegations or that the judge is finding so persuasive here They're basically saying that if a candidate wants to win again, then that is him acting in his official capacity because he just wants to govern some more. And all my governing is an official capacity. So then what the court just did is really say that that's not true. And not only could you say maybe, Clinton appointees, judges are saying that, but even Donald Trump appointees are saying that you cannot just say as a president, if I want to continue campaigning, it's official because I want to continue to govern. That argument that Donald Trump's lawyer is putting forth was resoundingly by all judges, said that is not the law on presidential immunity. And he's going to have quite a lot of bad facts to put out. And I always love seeing the fact of what Donald Trump and his lawyers use to kind of be used against him. His own statements, his own actions, because he's constantly changing and twisting his story. And when his earlier stories are used against him, I find that personally the most satisfying. And the majority opinion in this case speaks to the fact that when Donald Trump, took his case to the Supreme Court saying that there have been election irregularities and you should look at these state cases that have, denied me the ability to move on. He specifically says in there that he's taking this case in his personal capacity. He specifically is saying that in his pleadings, and the official, and the majority opinion here quotes him as saying that. And it's this idea that he wants to be able to say one thing in one legal case and a whole other thing in another legal case. And you may be able to do that in politics. You may be able to lie to our faces and say what kind of ever speech you want and be protected by free speech. But when you say something in one legal case and it becomes a pleading and a document that is going to sit there forever, it will be used against you if you try to say something different in another pleading and a document. And that's what's happening here. The majority opinion saying he even is admitting that he was acting in his personal capacity in talking about what he says are irregularities in the election and why he thinks that the certification should be stopped. The speech on January 6th, everything leading up to January 6th, he himself is saying that it's in his personal capacity. So, based on the facts have never been in Donald Trump's favor in relation to whether or not he should have immunity for his actions on January 6th. And now the law with the Court of Appeals in DC affirming, even the judge appointed by Donald Trump himself, affirming the fact that if the facts end up being proved as they have been alleged in the further motion summary for judgment or a trial, then Donald Trump will not be able to have immunity from civil suits. And I think this is going to then go on to the criminal, and we will have a similar ruling in the criminal for him not to have immunity on his actions related to January 6th because they were personal and not official. My name is Dina Sayegh. Thanks for listening.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.